Hello, everyone, and welcome to this first session of our training, Intellectual Property for Deep Tech Businesses. This training is organized by the European Patent Academy of the European Patent Office and the European Innovation Council and SMEs Executive Agency, supported by the European Intellectual Property Help Desk. My name is Stephanie Weber, and I'm a member of that European Intellectual Property Help Desk, an IP service initiative of the European Commission. We've been collaborating with the EPO and the EIC for quite a while now, and I'm delighted to be your host today, navigating and guiding us through this fully packed training agenda. So let's dive right in. In recent years, we've been witnessing the so-called fourth industrial revolution. Some call it a new era, which is defined by rapid advancements of new technologies such as Internet of Things, 5G, artificial intelligence, and cloud computing. And these technologies are not only shaping and reshaping our industries, but also redefining how we work, interact, and innovate, essentially how we live. So for startups and high growth businesses oriented or businesses working in this sector and being at the forefront of these advancements, intellectual property is not only a legal requirement, but it's a strategic asset that can safeguard a company's competitive edge and is often a decisive factor in attracting new investment or achieving a successful exit. So with this training, we would like to provide you with very practical knowledge and insights how to leverage IP for business growth and informed strategic decision-making. And we're incredibly happy to see such a great turnout this afternoon and really hope that you will have an insightful and inspiring afternoon with us. Today's session will be all about strategy. So we will be tackling questions such as why is IP important specifically for deep tech businesses? What are commercialization opportunities that you have? How do you combine specific IP rights in order to protect your business? And lastly, we will also get to the essence of what an IP strategy actually is and how you can put it into practice and implement it. Plus, all of this will be topped off by, as said, very hands-on examples and case studies. The second session next week, which we hope you're all registered for too, same day, same time, will then take a closer look at intellectual property management. Before we start, just a few more words on our housekeeping rules. So the first part of this training is dedicated to a set of very concise, to-the-point talks. We will run through these talks seamlessly, and hopefully, with being a little bit ahead of time, we will have the time for a brief Q&A session. To this end, we already encourage you to write your questions in the Q&A function during the talks. We will collect them, we will sort them, and then relay them to the plenum. Should we run late, we will take the break after this first training part and then have the question answered in the Q&A session foreseen for the end of the training. Also, very important question, also a frequently asked question, the presentations will be shared after the training as well as the recording. So be aware we're recording the session and we will share that with you shortly after the training as well. And lastly, of course, we want to do better, we want to improve, so we want to hear how we did in your opinion. So we will launch a very brief survey right after the training and would very much appreciate if you take a minute to fill in the questions. So with that, I think we're all set and ready to go, and I'm very pleased to introduce you to our first speakers. First of all, we have Viorel Peca here with us. He's the head of unit of EIC Transition. After joining the European Commission in 2008, he's held several leadership positions at the intersection of deep tech innovation, digital transformation, and strategic R&D policy. Viorel, very warm welcome to you. Great to have you here. And then we also have Raquel. She is the director of the European Patent Academy of the EPO. Raquel holds an LLM from Columbia University Law School and a PhD in law from the University of Barcelona. And before joining the EPO in 2023, Raquel was Dean of the School of Law and Political Science at the Universitat Oberta de Catalunya. Also a very warm welcome to you, and the floor is yours.
Thank you, Stephanie. Good afternoon, everybody. It's a real pleasure to be here and to welcome you and I would like to start by a word of thanks for our collaboration with the EPO. Raquel, really, we are very happy with the collaboration with EPO. As you know, we also have a MOU, and this collaboration is pretty wide. For us, in transition, it starts with EPO collaboration for analyzing the transition proposals that make it to the interview. And this provides us a very valuable insight into the project portfolio and the IP positioning of these proposals that make it to the last stage of our evaluation. What we have seen from this exercise, from the last exercise, for example, in 24, the EPO analysis showed that a relevant IP portfolio correlates with higher chances of success, our funding, and that's why we have realized the importance of coming to our applicants, but also beyond, and providing more information about IP. But this is not the only let's say data points that we have. Also, some of our participants may know the EPO report that maps the European investors, and there what we see is that half of companies funded by EIC have patent portfolios, and for the EIC fund, this is going even up to 3 out of 4 companies. So this is a very, very strong correlation. And also in the private sector, the deep tech investors also favor and are looking for companies with solid IP strategy. And why I'm saying this solid IP strategy and IP portfolio, because we have seen from our point of transition projects is that many of our projects struggle with setting up effective IP. And there is a difference between having IP and having effective IP, the one that really protects their product and shows their unique selling proposition. So that's why we have come with this idea of having a training where we can go beyond our beneficiary or our applicants and explain the building the IP capability and IP strategy. So that's why we have, and I would like to thanks again for working together to deliver this training. And here I would like to thank particularly my colleague Adéla Dvořáková, who has been here at the core of implementing this, and numerous EPO colleagues that are really already now, I think this is the third or the fourth training that we are doing together, and looking forward for the next one. So thank you very much for attending this training, and we are looking, as Stephanie was saying, we are looking forward to your feedback at the end. Enjoy the training.
Thank you. Thank you, Viorel. Thank you, Stephanie. I'm going to also here join and once again let you know that we are delighted to be joining efforts with the European Innovation Council and co-organize this activity on IP management and strategy for deep tech businesses. As you know, we at the EPO, we believe that supporting innovation goes beyond the granting of patents. We are in the business of granting patents, but we go beyond. This is why we have the EPO Academy that I am, I have the honor to direct. We have the EPO Observatory on Patents and Technology. We have the PatLib Network, and all this is joining efforts into supporting innovation. We are also very much aware of the fundamental role that businesses and entrepreneurs play in shaping our markets and basically shaping our society. That's why we are very proud to contribute today to this training, once again with the EIC, and share the expertise of our teams and partners. As you will see, we have built a program that is basically meant to share knowledge and help deep tech startups, that's innovative businesses, protect and manage their IP assets. We'll try to address the key challenges that they may be facing, and we're very much looking at decision makers to help them manage their IP strategically. Stephanie was reminding us at the beginning that IP is not just a legal formality. IP is a driver for creativity, for technological development, and it fosters economic growth, and ultimately it brings societal benefits. We believe in IP. It has been proven that it works, and we are convinced that IP is where the real transformation of the European economy begins. So for any business, for any startup, deep tech startup, it is never too early to have a clear understanding of IP assets, IP law, and IP strategy. The sooner you start, the better, and it's never too late. So this is the reason why we are all here today. I also hope you enjoy this activity, and I do hope to see you all, or many of you, also attending any of our academy trainings that you can find available on our e-learning center. And that's it. Before I leave you to it, because you didn't come here to hear us all, but to look and hear at the experts, thank you so much once again, the EIC, and thank you to all the speakers for taking your time and your effort to share your expertise and your insights with all of us. Thank you and enjoy it.
Thank you, Raquel.
Thank you very much, Raquel and Viorel, for setting the stage and for your encouraging words. Indeed, we believe in IP, and we also believe it's never too late. So thank you once again. And with that, I think, yeah, we're ready, and I'm very happy to introduce you to the first speaker, to the first talk, which will be given by Ilja Rudyk. Ilja is a senior economist at the European Patent Office, and he provides economic insights into issues relating to innovation and technology commercialization, has co-authored several studies, case studies, etc. So he's very well versed. And as we heard, IP is important. IP is particularly important for deep tech businesses, and Ilja will now tell us more about why.
Thank you, Stephanie. So many thanks to Raquel and Viorel for setting the scene, and I will try to continue in that spirit and provide you with some insights into why patents, IP, and intellectual assets in general are important for startups, what we know, what we think we know, and also maybe some advice of how to communicate about IP, because it is sometimes it seems that it's a strange word. For those who are working in that field, it is of course not, but for others it might be, and therefore it's also important to know how to communicate about IP, which will be part of my presentation. So let me briefly motivate of why actually we are here and why it is important and what actually happened in the previous year. And this is easily illustrated in one slide. So if you look at the transition of the industry that we have encountered over the last 40 years, we will see that we have been moving from more of a physical society to a more intangible society in terms of value that are associated with our largest and most important corporations. Just to provide you with a few numbers, a study has looked into the share of the value which is associated with the largest company, in that case in the US, so the S&P 500 market value. And if you look at the developments over the last 40 years, they see that the value has transitioned from tangible assets, be it machinery, be it inventory, be it land, buildings, and so on, to intangible assets such as patents, such as trademarks, software, brands, and more and more data and IT-related assets. So we do have a shift here, which also means that growth is in intangible assets, value is intangible assets. This is why we need to talk about it. This is why we need to also to understand how it helps and how especially deep tech company can benefit from it. Therefore, I am from the Chief Economist Unit of the EPO, and one of our role is to see what is actually the benefits that companies, in particular startups and small medium-sized enterprises, actually derive from IP protection and in particular from patent protection. And this is what I would like to present to you and to give you a few numbers, especially if you communicate to investors, if you communicate to peers, if you communicate to policymakers, if you want to convince others why IP is important, not only to convince you why IP is important, but also your potential stakeholders and partners. So these are the few numbers that we were able to generate in cooperation with the UIP office in Alicante. So the first question that we were asking already some years ago is whether companies that are using and owning IP rights, in particular designs, trademarks, and patents, whether they're also able to generate higher revenue per employee, which one of a possible metric for economic success. And indeed, we saw that companies that own IP rights are able to enjoy 41% higher revenue per employee. But the most interesting finding was when we looked at larger and smaller firms separately, we saw that most of the premium from IP protection was actually generated by small and medium-sized enterprises with 44%. Of course, we didn't stop here, and we were also wondering whether there are other indicators that are highly correlated with IP ownership. And indeed, we looked at those small, medium-sized enterprises in the technical sector, and we asked the question whether IP owning small, medium-sized enterprises, whether they are better able to grow fast, and to grow in several consecutive years. And indeed, here we found also correlation between IP ownership and the possibility of the company to grow, not to grow from 1 year, but also to grow for several years in a row. And as you can see here, the likelihood is much higher, not only to access a high growth period, but to grow also in general. And in particular, we also saw that if a company had a strategy or intention to go international, and if that was supported by European IP rights, such as the European patent or European trademark or design, that was also associated with a higher probability for the company to grow. So it seems that there is support from the European IP rights to startups if they want to scale and to grow in Europe. So again, here we see significant correlation between the higher revenues or higher performance, and also the probability of a company to scale and to grow not only in 1 year, but in several years in a row. Of course, we know that that not every SME is equal, and we know that we want especially the technology startups, the deep tech startups that we have, to grow and to scale. Therefore, in another approach, we looked whether startups, especially technology startups, that are owning IP rights, that they rely on IP protection, be it patents, trademark, or both, whether that helps them to get funding. That is the first question that we ask. And the second, whether there's also a benefit for the investors, because we do hear often the story or the argument that IP is important for investors, and we wanted to provide numbers for that, not only as a benefit to the startups, but also if there's a benefit for investor in that case. And I will show you in a few minutes whether there is a correlation with a higher likelihood of a successful exit. And as you will see on the next slide, we found 3 things. First of all, we see that the ownership of IP is highly correlated with the growth and scaling of the company. So the larger the company becomes, the faster it scales, the higher is the probability that that company also has a certain IP portfolio, be it patents, designs, or trademarks, or more. So if you can see, especially in the late stage where we already have larger companies that are working on European-wide or international markets. Here, the IP ownership is very high, with patent ownership almost at 50%. So what we observe is that IP ownership becomes more and more important, especially if and when a company scales. Second, we also investigated whether the probability of getting funded also increases with the ownership of IP. And what you see, yes, it does. Again, first finding is it is correlated with the growth stage of the company. So for seed stage, the advantage might be a bit smaller than for early stage companies, where the probability of receiving funding is almost or even more than 10 times higher for companies that own patents and trademarks. By the way, if you can see, if you see on this slide, you see that the probability of getting funded in case that you have a trademark or a patent is lower than for companies that have patents and trademarks. For us, a company that owns patent and trademarks is an indicator that the company knows how to manage its IP efficiently. And that will also become important during the day-to-day and also during the next session, where you will learn what it means to manage IP to the advantage of the company, and in particular, what it means to adjust the IP strategy to the business strategy of the company, because that has go hand in hand with each other. And here we see evidence that indeed, if a company understands how to manage the IP, and an indicator here is that the company knows that there are different types of IP, and they are going hand in hand, meaning they are complementary to each other. Here, we also see the highest benefit for the company in case of getting funded in the next round. Now, as I already mentioned, there's also a benefit for the investor. And as you can see here, the likelihood of a successful exit, be it through an initial public offering or being it through a successful acquisition, doubles. In case of trademarks, increases by factor of 2.4 on average in terms of patents. And again, if a company owns both patents and trademarks, which is an indicator of good IP management practices, then it even increases the factor of 3.2. Now, these were the numbers which you are free to use. You can use those numbers to discuss with your investors, with your partners, and so on. But of course, the question remains: okay, we saw those benefits, or at least the correlation with performance indicators. But why or how companies actually benefit from IP? And here, what is an important takeaway is that there is a holistic approach. There's not only one reason for patenting. There are usually several reasons why a company might or should be interested in obtaining patents and other IP rights, and those reasons might even change over time. And the company can benefit from those changes because it has IP. So you see, it goes hand in hand together. And just to name a few advantages or the most important benefits that IP brings to technology startups. First of all, there are market access reasons, so you can actually protect your technology or your invention from imitation. So you have some market power. You can use it to obtain freedom to operate here, and I hope that point will be touched by my colleagues. Please bear in mind that an invention is not the same as a product. Which means that you have to take the freedom to operate issue very seriously. Sometimes just having a patent is not enough. You have to think broader in terms of an IP management and IP strategy concepts, and to take the whole product and the market into consideration. But we will come to that, or my colleagues will come to that later during the day. Third, and this is what people often forget, think about the reputational aspects. How many times you've bought a product and there was written a patent, it is protected by a patent, and usually it gives you a better feeling, or it creates a reputation of technological superiority, which, as you will see on the next slides, is indeed one of the main reasons why especially younger startup companies obtain IP protection. Then in terms of business models, think about the licensing opportunities. You can even sell the technology. and it's much easier if it's protected through an IP portfolio. You can also use patents in negotiations with your partners as a negotiation chip, or to create some negotiation power on your side. Funding, we touched upon that point. Also, if you think about collateralizing IP, that would also give you an opportunities to get funding. And last but not least, the strategic value, meaning that it gives you the opportunity to adjust your business model by benefiting from a strong IP protection. And we will present you a few examples how companies, because they took a portfolio, or not portfolio, but let's say a technology platform approach when creating the business, they were able to pivot in the business model and finally be successful on the market. So as you can see, there are many advantages, and we try to capture that with some of our surveys that we did in different technology areas. As you can see, what we see throughout all technology areas is that companies usually derive different benefits from patent and IP protection. The only thing that differs is the weight that they're giving to the different benefits. For example, when we're talking about the fourth industrial revolution, so the digital technologies here, it seems that especially the reputational aspect and the freedom to operate aspects are more important than prevention from imitation, so to fend off competitors. While if you look at the clean tech sector, where you have more products than processes, it seems that the prevention of imitation is the most important aspect. Also, it doesn't mean that the others are not important. It's just that the weights and the priorities in the different reason to patent, they differ by industry. Now we're coming to the last slide, and as I mentioned in the beginning, it's also important to communicate about IP in the proper way. We know that it's more or less partially considered as a legal topic, but as Raquel already said, we should look at IP as assets and less as an insurance or just a protection mechanism. Therefore, what I would like you to have a look at is this short dictionary of IP to business terms. And just to give you a few examples, IP prosecution, so the process of acquiring IP rights, you should rather consider it and also communicate about it as an asset investment, because by acquiring patents, for example, you can have a cost advantage because you're the only one who can use that process to reduce the costs. Or if it's a protection of a product, then of course you can demand a price premium, which again gives you higher profit at the end. So related to that, exclusion or injunction, so the right to enforce your patent, you can also consider it as having market power. Again, you can exclude others from a market, or you can command higher prices because you have the protection through a patent or a trademark. The same for licensing revenue. This is nothing as a cash flow, and you will see later on that cash flow can, for example, be used as a complementary to other funding mechanism, or to, for example, to fund new R&D developments or an access to a new market. And I will present an example later on during the day. Same for IP infringement. IP infringement, so even if you infringe on another company's patent rights, that can be the beginning of a successful partnership or cooperation. For example, the possibility to make sure that you can access each other's technology through, for example, a cross-licensing agreement, or by identifying a potential partner with whom you could develop a technology better, or put a product on the market together. So I hope that the final takeaway is that there is, of course, the more risk-averse view on IP, you can, of course, look at it as a mere protection mechanism. However, I hopefully was able to convince you that it's better to look at it from an asset perspective as an investment into market power, into negotiation capabilities, and that IP creates value for companies. And I thank you very much for listening to me.
Thank you very much, Ilja. I think you presented us with quite a few convincing arguments for the potential for value creation of IP. So thanks very much for that. And following right up is, as you mentioned, your colleague Christian Soltmann, also a member of the Chief Economist Unit at the European Patent Office. He holds a PhD in material science and a master's in intellectual property. Welcome, Christian, to this session. And with you, we're gonna dive a little bit deeper into, the practical commercialization of IP, also sharing some pros and cons, and we're looking forward to your presentation.
Thank you very much, Stephanie. As a follow-up to Ilja's presentation, we would like to take now the opportunity to go one step back. Ilja provided a very comprehensive overview of the value of IP for deep tech businesses. In this presentation, before Bente will provide a more extensive overview of intellectual property rights and the system of these rights, just from the perspective of entrepreneurs, those who are involved in deep tech businesses, the importance of intellectual property for the commercialization of their technologies. The future you aim at is, of course, to achieve some commercial success using your technologies. This is where you are taking maybe the position of a materials engineer. You develop products, services, machines, programs that run these machines in order to produce a product. You also need, of course, other aspects that need to be covered to create software, to create brands, trademarks, etc. And what you would like to achieve is either to use these technologies on the market for the production and for the commercialization of certain products, to offer services, or as an alternative, very important for those who are either not in a position to commercialize technologies or are not interested in to establish a legal and commercial relationship with others who are in a position and who are willing to take the opportunity and commercialize the technology. It sounds like a very good fit, the piece of cake to arrive from where you are, from the workshop, the laboratory with your technologies to commercial success. But it's important to realize that it's very slippery, and that has mainly two reasons, because what your technology is essentially is know-how and information. You have to know how to use materials, for example, to run machines, to create a certain product or to offer a service. And once this know-how and the information is available in the public, it may be reproduced technically by everyone, usually at moderate cost, which creates a competitive advantage for others, as opposed to you who were in a position to invest first a lot of money for equipment, for research and development, for facilities, etc. And once the information is in the public, it's no longer possible to exclude others from using the knowledge and the know-how, except for situations where this know-how is protected by intellectual property rights. And that's the key aspect and the value of intellectual property rights in this system. As mentioned, Bente will provide an overview of the different kinds of intellectual property rights to protect different aspects that are important in the commercial environment. Here, I just would like to convey the message that it's very important to use the intellectual property rights. Ilja provided already a general economic overview of this aspect. Here, I would like to mention to use it in your daily environment, either when you use the own products and services, because you need to protect the technology on the markets where you would like to create a commercial revenue. That's one aspect how you can use now your intellectual asset, which is protected by intellectual property rights, if possible. Second option to commercialize your technology is, of course, that the technology may be used by someone else who is entitled to do so in an environment where the technology is protected, and the other aspects that also contribute to it. We mentioned already logos, trademarks, designs, etc. There are two aspects how this may happen. First, you transfer the intellectual property rights which protect your technologies. This is what we usually call to sell a technology, or as an alternative to enter into a license relationship with someone else, either someone outside your own environment, or possibly by creating a spin-off to which the rights are transferred by agreeing on licenses to the spin-off, then have it commercialized by those who are experts. Okay, there are essentially the four options I mentioned already. When it comes to licenses, maybe some of you are not familiar with the concept of licenses. There are two parties. First of all, the owner of the intellectual property rights that help to protect the technologies on specific markets. This is what officially is called the license, so from a legal perspective. And then there's the licensees. So, for example, a company that wants to receive a license in order to take commercial actions with the technology that is protected by intellectual property rights. There are two aspects that need to be taken into account. First, that a permission has to be given to the licensee in order to use the intellectual asset, which is protected by the intellectual right. Essentially, this is the permission that the licensee can take commercial actions without running the risk to be sued by the owner of the intellectual property rights. In return, of course, things are usually not free. There is a compensating measure, for example, by paying royalties. And this relationship, so how this license should work, is established by the so-called license agreement, which specifies the conditions under which the licensee can use the license, the intellectual asset which is protected by the intellectual property rights. So the intellectual property right is the key aspect here, because without intellectual property right, there would be no incentive, or nearly no incentive, for potential licensees to accept the license. The licensor, using a license agreement, still remains the owner of the intellectual asset. And because intellectual property rights are generally based on the principle of territoriality, you can define different conditions, for example, for patents, that different licensees may exist for different markets or different countries, or even within countries, you may define certain conditions to commercialize. And you, as the intellectual property owner, can still assume the right to commercialize the technology yourself. So basically, there's a wide spectrum of different options how you can use licenses to help commercialize your technologies. If you're more interested in licenses, we can recommend two publications. You can see here the references in the slides you will receive. You can click on it and are then directed to the publications in question. Yeah, I mentioned the different commercialization routes. You can produce and sell your products and offer services. You may license the technology. You may create a spin-off, for example, which may then license your technology, and you may transfer the IP rights. Essentially, this is what we call selling the technology. There are pros and cons for each of these four options. For example, for when it comes to selling the products or offering the services, it may involve the potential for high and long-term economic return. So it's really economic opportunity for you to maximize the economic return for the technology you developed. You can also control the branding, loyalty, other aspects. The disadvantages are it usually requires, especially in the area of technologies, significant investments. There are market risk. It's difficult to scale the technology, the production and the commercialization of a technology rapidly without contributions by others. So there's usually a situation for many of us where the commercialization by yourself is hardly possible. That's why the alternatives may be so useful. When it comes to licensing the technology, of course, the monetarization of the intellectual asset is important without substantial own investment and risk. The disadvantage is that you usually, if the license conditions are not properly set, waive control over the commercialization, and in case the licensee is not capable of creating sufficient economic revenue, you are also set as a disadvantage. Other reasons to license is, apart from creating revenue, is to access a specific technology from the perspective of a licensee to ensure freedom to operate. Ilja mentioned this already, and to stop infringement. That's the perspective of the licensor. And in the end, to cross-license, to back-license, and possibly also to establish joint R&D activities. Yeah, creating a spin-off is something like a more controlled manner to commercialize. It's between own commercialization and transfer. You still keep spin-offs, for example, in your own environment. You equip them with the intellectual property rights or the licensees to it, so access to the technology in order to be commercially acceptable. Last but not least, the last option that is presented here to transfer intellectual property rights to sell the technology is a quick way to create an income, to have more financial resources for other activities where you have a higher specification, but there's also the risk that you have the permanent loss of the rights on the technology, and it cuts you off from future revenues regarding the technology. Still, even though it sounds like a quick win, transfer the IP rights, it requires a diligent process for the transfer, which may also take time and tie up a lot of resources. So for each of these commercialization opportunities that are related to technologies supported and actively driven by intellectual property rights, you will see advantages and disadvantages. And I'm confident that in the course of this event, you will have a clearer understanding in which situation you are and what may be the optimum opportunity for you. Yeah, that brings me already at the end of my presentation. Many thanks for your interest. And yes, I will be available for questions at a later stage. Thank you.
Thank you so much, Christian, for this very concise overview, specifically concerning the pros and cons. And as you rightly mentioned, or several people in this session already mentioned, we think beyond patents, we think in broader terms. And so when we talk about the strategic value, Ilja mentioned that, Raquel mentioned that as well, we're not only talking about patents, but there are other IP rights, for instance, trademarks, as we've heard, design, trade secrets, and combined in a smart and strategic way, aligned to the business strategy, as Ilja also mentioned, they can really become a powerful tool in protecting and growing your business. But how to do that is the question. And thankfully, we have Bente Fjeldberg with us today, who will now help us explore a little bit how potential combinations and strategic objectives could look like. Bente is a seconded national expert from the Norwegian IP office, currently working as a training and network administrator in the PatLib department of the European Patent Academy at the EPO. And she's extensive experience in the field of intellectual property, both from the private and the public sector. So a very warm welcome to you, Bente, and we're eager to hear more about knowing our IP.
Bente, you are muted.
Yes, we can't hear you, unfortunately.
Unmute. Can you hear me now?
Yes, and we can see you too. This is great.
Lovely. Then we'll start again. All right. So hello, my name is Bente. Thank you for the introduction to you, Stephanie. I'm going to present to you an overview of the different types of intellectual property rights, and also say something about the combining different types of intellectual property rights to fit your needs. But first, I thought we should start by clearing up some misunderstandings. The terms IP and IPR are often used synonymously, and there's a bit of a confusion regarding the difference between these two terms. Simply put, intellectual property refers to new and original creations that set the creator apart from others. Simple. But then again, intellectual property rights refer to the exclusive legal rights that are granted to creators for their intellectual property, which means that the intellectual property rights only refer to the rights that you are granted if you take specific measures to achieve them. So there's a little bit of a nuance difference there, the legal rights. So when it comes to combining such intellectual property rights to protect your business, well, then fortunately or unfortunately, or maybe luckily, there is no one size fits all, no one answer that is right for everyone and every situation. Putting together the appropriate IP portfolio is individual for each company and can therefore be tailored specifically to your needs, which is a big key. Have you created a product that would be difficult to reverse engineer? Then maybe you should consider protecting it as a trade secret, maybe combined with some features that could be smart to patent in addition. If you have developed a product that you want to sell to the market leader, then maybe a patent would be the right thing for you if that is your exit strategy. Maybe you have designed a product that competes with many others in the marketplace. Securing the trademark for your company's name, the product name, if any, and a unique design is a very good idea. And maybe you are looking for investors, or you want to cooperate with another company to develop something new together. Securing the intellectual properties of your company is a smart move because you can prove what you bring to the table. You can prove ownership of what you bring to the table. And being able to show that ownership of your intellectual efforts and your assets means that your company has exclusive rights to exploit them. For example, through license agreements, just like Christian talked about just before. So there are many combinations depending on your specific situation. The decision of what is right for your company should be tied to your business plan and anchored throughout your organization, including all the way to the top. And if you don't have in-house IP expertise, I would highly recommend that you talk to a professional who, together with you, can evaluate what the best strategic way forward for your company is. Maybe it comes when it comes to securing your intellectual property rights. Maybe you need all of these rights. So here are the most relevant types of intellectual property rights: patents, trade secrets, trademarks, industrial designs, utility models, copyright, and databases. And very often we see that one product or one service requires more than just one type of protection. In an ideal world, of course, you may want to go for all of these. But as you know, securing your IP can be a very costly thing. So it's important for you to consider from the start how you intend to cover these costs. A patent process is rather expensive, and you need to think about how you're going to finance it. Maybe you need to consider keeping things a trade secret instead, at least in the beginning, until you have the financial strength to start the process. And also remember, there are not just the initial filing costs, but also the costs of paying the annual renewal fees. So at the planning stage, make sure you also think about how you're going to finance your intellectual property rights, and start thinking about it early. Here is a very quick overview of each intellectual property and how it's protected and how you go about the protection process. So trademarks, as I'm sure you all know, protects the distinctive identification of a product or a service. It could be your product or company name. It could be a logo, a slogan, or a design, but it can also be a particular color. For example, like the red soles of Louboutin shoes. It could be a sound, like a jingle, or it could even be a motion. Trademarks are protected through a registration process or also through use, but to prove your trademark through use is a much longer process, so going for a registration is a much better choice. Industrial designs protect the external appearance of a product, and it's also then registered through an application. Trade secrets protect valuable information that is not known or should not be known to the public, and you need to make reasonable efforts to keep it secret. I'll come back to that a little bit later. Patents, as I'm sure you know, protect new inventions. There's an application process that includes an examination. Utility models are often called patent light. They also protect new inventions. It's protected through an application and a registration as soon as you have fulfilled all the formalities. It's a much shorter and cheaper type of protection. We'll come back to that as well. Copyright protects original and creative forms of all sorts, from pictures to movies to literary work, anything artistic or creative. And it exists automatically when it's created. So trade secrets, design rights, and copyrights, especially for digital inventions, will also be covered next week by Rainer. So you will hear more about that then. I wanted to fit in one more line, but there was no room. So I've made this extra database slide, because your database can also be considered intellectual property of your company. And there are ways to protect it. So through copyright, you protect the original structure of the database. And the sui generis meaning of its own kind, protects the original content of the database. So the copyright will grant you exclusive right to reproduce, adapt, distribute the database or a variation of it. The sui generis right protects the content, but there are certain criteria that you have to fulfill. For example, the maker of the database has to be an EU national or an EU resident. So this is very specific to the EU. But you also have to be able to prove that you've made a substantial investment in the database content. If you fulfill these requirements, you are automatically granted the protection for 15 years, starting either from the creation date or from the date when the database was first made publicly available. And with this right, you or the maker of the database can prevent the extraction or reuse of the whole or a substantial part of the database content. So for many deep tech companies, this could be a very valuable source of protection. So like I mentioned before, one product may have many types of intellectual property rights. For example, this is a smartphone, although a relatively old model, but still. It's covered by trademarks, both from the producer, the product itself, and even the start tone. There is a lot of copyright underneath in the software and user manuals and ringtones and images that are used. There are plenty of patents and utility models covering the technology that goes into this smartphone, and lots of different types of design registrations, from the overall shape of the telephone to the user interface, where the buttons are placed, how the buttons look, and the overall shape of the screen, and many different things. And there are even some trade secrets, some technical know-how that is kept in-house and has so far never been published. Briefly coming back to patents, I just wanted to also remind you of the 3 criteria that must be fulfilled for an invention to qualify as a patent. Namely, that it has to be new, which means that it goes beyond what is known already. The invention also has to involve a so-called inventive step, which means that the technical solution of the invention should not be obvious to a person skilled person in that field. And finally, that the invention must be industrial applicable, which means that it must be possible to reproduce or manufacture or perform the invention. And all of these must relate to an invention that is either a physical entity, such as a product or an apparatus, or a physical activity, such as a process, a method, or use. And again, back to what Christian also talked about, and even Ilja mentioned this, the basic principles of the patent system is that the letters patent that you receive when you have received a patent is like a contract between you as the owner and the public. By sharing your invention with the public so that others can build on the technology and knowledge that you share, you are granted the exclusive rights to exploit the invention for a limited period of time. For example, maximum 20 years, provided you pay the renewal fees. But that should be sufficient time to establish some market strength. When should you file for protection? Well, that is also something that can be discussed at your board, in the boardroom. If we look at, for example, trademarks, it's important that you have checked what exactly is it you want to protect. What is the trademark you want? Is it available? Does somebody else use it already? Is the domain name and or the company name still available? How about social media handles? Do you want this trademark to be your descriptor? And another thing you need to consider is, can your trademark coexist with another if they are similar, but they're used for different products and services? So it's very important for you to check early. The registration happens through national or regional applications. An industrial design can be achieved also through national and regional applications. Also here, it's important to check early, because you don't want to file an application before the design is final. Remember, a design application or registration covers the physical appearance of a product. And if you haven't finished designing it yet, then you may get a protection for a product that doesn't exist. It's also important that you file the application before you show it to the market. You don't want to stand in your own way. Trade secrets. It's important to document with dates all the way from the beginning, and you have to prove that you've taken reasonable efforts, to keep it a secret. For example, it can be done through restricted access to sensitive areas or to sensitive materials. You could keep a visitor log. You have security monitoring. You can keep data records of sensitive documents, always with dates, types of employee training, and knowing what your competitors are doing. All this combined can give you a trade secret. Patents should not be filed after you have disclosed it. Then you have you've pulled the rug under your own feet. It's important that you also don't file too early, because you have to be able to explain how an invention is implemented. This was the third criteria that I mentioned, the industrial applicability. You have to be able to show how it's implemented. Again, it's very important to check early, do preliminary searches, and applications can be filed either nationally or through regional applications. Utility models, often called, like I mentioned, patent light, should usually be filed before a patent application. Many people start with a utility model application before the patent application because they are both cheaper and quicker. But if you see that there's an opportunity to successfully pursue it, it can be turned into a patent application, or you can file a patent application with priority from the utility model application registration. Finally, copyright. In Europe, you actually have copyright automatically when the work is complete. There is no application or registration process needed at all. In what order should you file the applications? It's important to clarify the needs and the plans for your company. Again, there is no one solution that fits all, and everything can be tailored or should be tailored to your individual circumstances. For example, what do you need the protection for? Are you trying to attract investors? Do you want to establish your market recognition? Are you trying to secure your own freedom to operate? Are you looking for a joint venture, a merger, some other business opportunity? Also, you have to decide where exactly is your market and where will you produce what you're offering. That would also dictate a little bit where you would want to file and in what order you should file things. It's a good thing to know what your competitors are doing and what is already on the market. These are all business decisions. You know, sometimes we hear people say that they prefer not to protect at all. It's complicated, it's expensive, and they would rather focus on open innovation. There's a common misconception that open innovation means that you don't patent and rather just share everything unconditionally. But that's not necessarily the case. It actually means that you share knowledge to achieve new developments together with others. And therefore, it's necessary to set some important, clear ground rules. For example, that it should be very clear what problem you are trying to solve together. And are there any incentives for those who contribute? Who owns any new technology or any solutions that come out of your collaboration? It's important to set these IP expectations, and also who and when the ideas can be submitted. Open innovation usually takes place as a challenge or a hackathon, in a startup accelerator or a co-creation lab, or in a business partnership or an acquisition. And you can also share patented technologies with others in this type of setup. Open innovation in combination with patents can often prove to be very effective, and you keep control of who gets access to your technology. And you can stimulate and influence innovation without giving up your competitive edge. No matter what you decide to do and what you think is best for your company, having a good overview of the IPR possibilities is very important. And again, speaking to an IP professional is highly recommended. The more you know, the better use you can have of your IP professional. Coming towards the end here, wanted to show you a simple IPR protection timeline. As you understand, IP rights are like tools in a toolbox. It's important that you at an early stage carefully consider and determine which of the IPRs could be right for your company, and then make a plan. It does matter in what order you file. For example, if you represent an academic institution, there's often a battle between patenting and publishing. However, one does not necessarily exclude the other. It is, however, very important that the patent application is filed before you publish, or else you risk ruining the novelty requirement for patent applications. When and how to use them to achieve the best IP value for your company is something that Thomas will go further into after the break when he talks about the IP strategy. So finally, to finish my presentation, I just wanted to share with you these useful links. Here you can find more information about everything that I have talked about, and also some valuable resources for further learning. The European Patent Academy, our e-learning center, European IP Help Desk, very useful people to talk to, and the European Innovation Council. And I know that was a bit of a rush and a lot of information, but as has been mentioned before, you will all receive your presentations afterwards. Thank you.
Thank you very much, Bente, also for reminding people, because we see those questions flying in. Will we receive the slides? Will there be a recording? Yes, there will. And in the interest of time, I suggest we take a break now. As said, we've been answering questions already on the fly, my colleagues and I. So also have a look at the Q&A, just to encourage people, because some of the questions that come in repeatedly are being answered or have been answered already. And with that, I think we take a 10 minutes break and meet at 3:20, and then dive right into the IP strategy part, as Bente just said. Thanks, everyone. See you in a minute.
Thank you.
Hello and welcome back everyone from this short break, and thanks again to the first group of speakers in this first part who've paved the way, so to speak, for what's coming up now. You've heard a lot about the necessity to have an IP strategy, the importance to have an IP strategy, but what does that actually mean, and how can you turn that into real life, make that a reality? So this is what the second part of this training will be about, and we hope to be giving you some hands-on and real-life examples, make that really a little bit more relatable and break it down. What does it actually mean? And you see Thomas Bereuter here already with me on this virtual stage. Thomas is Innovation Networks Manager at Patlib in the European Patent Academy. He's a certified licensing professional with over 25 years of experience in the international commercialization of early stage technologies. So welcome, Thomas, and we're looking very much forward to your talk. And he'll be joined later on by Adéla Dvořáková, as mentioned by Viorel in his introductory words. She's also with the EIC Transition, a project advisor, and is a tech to market advisor, more specifically at the EIC Transition, working closely with researchers and innovators to help turn scientific breakthroughs really into market-ready products and businesses. And she'll chime in later and complement the talks with some illustrations and examples. And also Ilja Rudyk will be back later on. Thanks for switching on the camera at the moment. So he'll also join us later. But Thomas will kick us off now, and then we'll chime in. Thanks, everyone.
Thank you, Stephanie, for the kind introduction and the great moderation. Thank you. In this session, we will use content co-developed with LES International. That is an organization partnering with us and focusing on advancing the business of IP. So the right partner for such a content. We will focus on what decision makers in high growth tech businesses and of course their IP professionals need to know to define the right IP strategy. Let's start with a simple definition, short one. An IP strategy is a course of action to use intangible assets to reach an organization's long-term goals. I consciously avoided the word plan because a strategy is more than just a plan.
Thomas, I'm very sorry to interrupt. We can't see your screen. It disappeared.
Oh, okay.
Maybe you can yeah, I'm very sorry, but it would be a shame if we can't see your slides.
Thank you for spotting that. I have not experienced something like that before, but there's always a first time.
Yes, here we go. We can see it. Thanks so much.
Excellent. Thank you. Yes, so coming back to the aspect, the IP strategy is more a kind of pattern. It's not merely a plan. So we announced that we will include a lot of case studies. That makes perfect sense, in particular when talking about IP strategy, because there is no easy way to get to an IP strategy. It's always something that is tailored. I will elaborate on that in more detail. And for that reason, we are very proud that we have a library of great case studies online for free. But we kept getting one critic, and that is that the featured innovators, they mastered the challenges they had to overcome. So we were learning from their failures, but there was always a happy end. And that we got as a critic. And so let me start today for the first time with a failure case. The story of an inventor and his entrepreneurial path. It's a personal one that I know very well. It's about my father. So my father, he was a chemist. A traffic accident forced him out of the lab. Instead of taking a disability pension, he chose a one-time insurance payout and used that financing to kick off a business. And he also entered politics, and later on he sold that business. So he had quite a good start. At the height of his career, he wanted to combine all what it has done before, combine chemistry with entrepreneurship and social purpose. He found a problem worth solving in metalworking, a field harming workers, businesses, and the environment. He set up an R&D lab in his garage, developed a new class of cooling lubricants, filed patents on both the substances and the synthesis, as well as the application. The production was outsourced, sales began. The proof of concept was strong, but bootstrapping wasn't enough, and the business never reached critical mass. You need the economies of scale to have a cheap product in the market, and if you produce in small amounts, that's a challenge that is not working. So he had to pivot. He pivoted well and licensed the technology to a large company, but they lacked the long breath to build a new product line and broke the contract. In parallel, a US company infringed his patents, but he didn't see a chance to finance litigation. What he did was to go back to the startup route, and then VC, a venture capital-backed startup, followed, but it collapsed when investors withdrew too early. A new startup supported by a business angel failed again. They failed to scale in time. Again, he pivoted and sold the technology to a fierce competitor who eventually stopped sales, returning the rights to him. He explored new applications of the compounds, but then age and health excluded him as an active partner. So much was achieved, but at 91, after a fatal accident, lying in bed with almost every vertebra broken, he reflected differently. His first concern, of course, in his state was saying goodbye to my mother, that's clear. But his second concern, imagine having the pain, seeing the end near, he still had the concern that he had built lifestyle businesses, but not a scalable business, that had a sustained success. His mission to bring his invention to a global market remained unfulfilled. He died still thinking about how to make it happen. So let's see what went wrong and what we can learn from that. All main commercialization paths were tried: selling products, licensing, assignment, spin-offs, even strategic alliances. The inventor was entrepreneurial, passionate, resilient, and convincing. So he had achieved a lot. But in some aspects of IP strategy, in some aspects of IP management, and as well business strategy, he failed. And it was avoidable. He signed an exclusive license with a win-lose structure. So he was a tough negotiator and achieved a contract that I still could frame it and say this is the best contract in the world because it defines everything the licensor should get and hardly anything about the rights of the licensee. It was based on optimistic projections. And when the economics became a challenge for the licensee, my father, he refused to renegotiate. And that's a normal thing. So everyone who is in the licensing business knows that when the economics are not like predicted, you have to renegotiate because it must be a win-win relationship. So the licensee would have gone bankrupt had they stuck to the contract. So there was only one way out, that was to breach the contract. Another point was he had no plan to enforce contracts and patents. So despite being a tough negotiator, he had actually no means to enforce it. And that although an offensive strategy, we will talk about it later in more detail, meaning the monetization of the IP rights was the intent. Another aspect was that he signed NDAs, so he was aware of keeping trade secrets, that this is an important thing, but he didn't actively protect trade secrets as required. Like Bente already mentioned, you need to take active measures. And that later on limited the options once the first patents started to lapse. So I stressed that he actually mastered pivoting. So he changed the business models. He went for other partnerships, financing, and so on. but what he lacked was a structured IP management. Poor documentation meant he couldn't build on earlier progress. So it was often that he started not really from scratch, but he did not build upon what was already achieved. And related to that, he lacked customer continuity. So each time there was a new mission on, he started from scratch, contacting customers and so on. And that resulted in an extreme dependence on external growth financing. So to sum up, had he built trust with his licensee, had he enforced his rights, had he managed IP professionally, and or kept customers close, he might have reached the critical mass needed for sustained success. And maybe one of those aspects would have already been sufficient for his success. And that is why we are here today, to turn others' hard-learned lessons into your advantage. That is our mission. So let's get back to the question, what is an IP strategy and what it is not? Today, or nowadays in general, the word strategy is often used too inflationary. Sometimes it is just used as a synonym for it's important. Sometimes it's used for a difficult tactic to implement. But for you to learn, it is better to avoid the confusion. So let's be clear about the wording. When interviewing businesses for our case studies, we often hear when there is an IP problem, we call our patent attorney. But strategy is not a legal issue, and it is something you cannot outsource. Strategy must be owned and driven by your organization's strategic decision makers. So there is no alternative to that. We also hear often, we file for priority in Germany and or at the EPO, and then internationalize via the PCT route. Again, sorry, how to delay costs, how to come efficiently to your IP rights. These are important tactical steps, but IP strategy is not a filing tactic. It's far beyond. As feedback, we also get, we have an IP policy for invention disclosures, and we are also proud having a policy for R&D corporations. But again, sorry, IP strategy is not a set of internal policies. They support the strategy. It's a good practice to do it, but it's not sufficient. Another misconception, this is for big companies. We don't have the resources for that, and we'll get to it right once we have the funding. It is the other way around. As a small company, you can't afford to work inefficiently, as you don't have the economies of scale, you don't have the deep pockets. The earlier you align IP with your business goals, the better your chance for success, especially in high growth environments. So IP strategy, actually that's the next point. IP strategy is not a reaction on the competitors' patents. Strategy, per definition, must be proactive. And finally, IP strategy is not about turning IP into business itself. It's about how IP supports your actual business model, not replacing it. So that is a point where we can also connect to EIC. So applicants are required to submit an IP strategy. Adéla, are you with us? Based on your experience evaluating proposals, does any of what I just outlined resonate with what you see in practice?
Yeah, I would say yes. Thanks a lot, Thomas, for this question. Indeed, I see in your list several misconceptions that we see in the applications for funding, indeed. So what I, for example, can relate to is IP strategy is not a collection of IP policies. So sometimes we see a description of IP policies in the applications, which is actually per se not wrong. I'm not saying that this is something wrong. It's actually right to have some IP policies and processes in place. But indeed, if what is requested is an IP strategy, it's not it's not exactly what is expected, let's say. So that's one of the things. What we see, for example, also a lot in the applications is IP matters will be regulated in the consortium agreement. So this is something that we see a lot, which is also correct. Consortium agreement is actually mandatory in the EIC. But again, consortium agreement is not an IP strategy document. It's a legal document that regulates some IP matters, but it's not something that replaces IP strategy. So yeah, we see several things from your list in the applications. And actually, what I like to see in your list is that IP strategy is not a legal topic that can be outsourced. That's something that I would like to stress. I think that this is good that you included it, because IP strategy, in our opinion, is something that should be internal to the company, and it should not be completely outsourced. Nobody should be doing IP strategy on your behalf. You can have advisors, you can have support, you can outsource specific tasks, but IP strategy should be actually internal to the business. So I would like to stress this. Thank you, Thomas.
That makes perfect sense, and also your link to the consortium agreement makes perfect sense. The consortium agreement, of course, is a typical thing that is an outcome of an IP strategy. That is the result, because then once you know what you want to do with your IP, you want to have the legal regulations with your cooperation partners in place that safeguard that everyone gets the IP that he needs for his business case. So that makes perfect sense. And it could also make sense in the consortium agreement to communicate the one or the other part of your IP strategy so that your partners understand why you want to have ownership in this case, access right in the other case, that they understand that this is not just out of the blue, but that is what you require for your business case. Otherwise, you will be not successful, you will be unhappy, and they understand that this is a requirement. That's a good practice and good communication. But as you rightly say, it's not an IP strategy. So let's dig into that deeper. Let me offer a simple analogy to set the stage for our deep dive. So to make it clear with an analogy, so strategy is the plan to win the war. Tactics are the battles that you fight to win that war. So it's connected, both matter. Strategy without tactics leads nowhere. It stays theory. And tactics without strategy, that's action without direction. A lot of effort and with the risk to have little result. So when we get to the bigger picture, right, you always start from your actual position. So what is your starting point? And you aim for a target. And your inventions give you a time advantage, but this time window is limited, and at some time it will close. So to stay ahead and avoid becoming obsolete, you need to reach your target in time. So then wherever you are, still in the university lab, already in business, what essential is, one step ahead, what essential is this: business decision makers need the telescope view. They must look far ahead and lead accordingly. Think about the IP rights. You know, Bente told you, informed you that a patent gives you protection for up to 20 years. So that's looking into the future. So you want to safeguard that you have the IP rights that you need at the time when it's required. So you must look ahead. And what are key principles of IP strategy? So that is, we mentioned that over and over again, you know, so we want to be sure that it is really something you take with you when you leave our training. IP supports business goals. It's not a legal side task. IP must align with your company's objectives, whether that's market entry, funding, or partnerships. And it's tailored to your organization. That is also why it's so difficult to do trainings about this topic, and why many try to avoid it, because it is tailored. There is no one size fits all. It's not a copy-paste approach. And then a strong IP strategy fits to your technology, your market, your business model, your resources. And if you are not a copycat yourself, you will not find the role model from whom you can copy the IP strategy. You have to develop it. And once you have it, you need to advance it because it evolves. Strategy is not static. As your business grows, or when you pivot, your IP strategy must adapt with it. It's like a tailored suit. If you gain weight, you might need a bigger size. Bad luck, but that's the reality. And so you need to adjust on the developments. Having said that, strategy is not what you change like underwear. Yeah, so you keep the line. So to win the battles, as mentioned before, you need an IP management system. This is where IP professionals step in, using the magnifying glass or sometimes even the microscope to see what are the details that need to be solved. Their job is to clear the hurdles and secure the right IP efficiently, and that also means at the lowest possible cost. There are three core features of IP management. It provides legal protection and compliance. So it covers filings, renewals, fee payments, and enforcement, all these aspects, ensuring your rights are valid, enforceable, and compliant. And the good news are, these are standardized processes and tools. IP management follows clear workflows, often supported by templates, tools, and increasingly by international standards like ISO and D norms. So don't reinvent the wheel. It's in contrast to the IP strategy, which is tailored. You don't want to come up with new concepts. You just learn from your peers how IP management is done as a routine-based. It's routine-based and made for repeatable execution. The goal is consistency. You want to avoid errors. You have to meet deadlines. You want to reduce risk and keep the IP portfolio in shape. We will deal with IP management in more detail on the second day. And of course, when you implement it, you follow the best good practice: plan, do, control, act. So that is a standard aspect of all management systems, that you follow this kind of project management. So to come to the next step, we know from business literature that the core goal for any profit-oriented company is to sustain an advantaged market position, and not just for a quarter or a year, but ideally over decades. And the same literature tells us that there are three distinct business strategies that consistently support this kind of long-term success. And importantly, successful companies choose one of these strategies and you stick with it. And if you, either you radically reset, you pivot, or you create spin-offs, because focus is here essential. So the first one is a unique desired performance. I think the majority of you are falling under this headline: unique desired performance. An obvious example is, think of a pharmaceutical company with a breakthrough therapeutic. If you, for example, offer to cure cancer, you might be offering something no one else can match. And as I said, I'm convinced that many of EIC beneficiaries, many of the participants will resonate with that goal. Another aspect is the unique low cost, low price. These are companies that you as consumers know, like Ryanair, like Aldi, like Lidl. They compete on price, and that enabled by a uniquely low cost structure. So the operational excellence there is essential. Of course, there are also innovative technologies that can trigger a revolution in producing products or services. With AI, we see many of these as well. So some of you might actually have a technology that is a game changer because it's just extremely much cheaper to produce a product with your technology. And then there is something that is for many of you rather an outlook, because it's about the unique trusted brand. So probably every one of you know Intel inside, Gore-Tex inside, Vibram inside, Dolby inside. All these companies started with technology and finally created a strong brand lasting longer than their original patents. And so these are the three main ways to have a sustained advanced business position. And today we will offer you a number of perspectives to define the right IP strategy that goes along with it. We look at it from different angles. And the first one starts here with a nice illustration with a pyramid. Then this slide presents the perspectives in a necessary order. So from bottom to up, this is an order. So they were not chosen arbitrarily. All organizations have 5 basic survival needs, which reflect the human needs developed by psychologist Maslow and known by most of you as the Maslow hierarchy. The needs of the underlying level have to be satisfied before a person can work on the next higher level. We will show you this by having you hold your breath. Try it. How long can you do it? This is a physiological level need. The same goes for hunger, for dehydration, etc. Without it, you can't live or work. Once you survive, once that is safeguarded, you go for safety. You go for love, for belonging, for esteem. And the highest level is the self-actualization. That is what humans want to achieve. Translated to business goals, shown at the right, that means the basic need for businesses are no surprises to current business. The next level is you want to have what we already discussed, the sustained advantaged market position over your competitors. You want to be better positioned than them. The next level is the full exploitation of all company assets. There should be no hidden treasure that is unspotted and unused. The next level is speed up R&D and product development, having short innovation cycles, coming out with the next generation of products fast. And the highest level is to develop a significant influence on the industry adoption of the industry adoption of new technology and business models. So that are, of course, the standards, the standard essential patents, for example, but it's also FDA-approved treatments, but it can also be business models. New business models like introduced by Apple in the music industry. The order of the business needs for profit operating companies is shown in this pyramid. So now let's see what is how that translates. So the business goals, how that translates into IP goals. There are 5 corresponding IP strategies to each of the business goals. At the bottom, an organization that doesn't have freedom to operate, it perishes. Freedom to operate means that you are able to sell your products, your services. FTO is a very basic need for every company that is selling product services. Of course, if you're selling R&D results, then it's different. You want to be allowed to sell your products and services, and nobody should be in the position to stop you selling those. Basic need. The next level, an ongoing organization has to manage its IP portfolio to keep competitors on distance from the most profitable products and keeping their costs at the lowest possible level. The third, the next level, in order to grow the business at the highest rate and optimize cost and revenues, most for-profit organizations engage in out-licensing programs for non-core intellectual properties. So an asset that you actually don't need, or it's not central, and you monetize on it. And the next level needed is to rapidly develop new desirable products and services. This is enhanced by in-licensing or purchasing, acquiring new businesses or technologies. These activities are often referred to as open innovation, what Bente already mentioned. Lastly, at the highest level, intellectual property is used in standards committees or pre-competitive collaborations to shape the direction of the industry, setting standards as mentioned, or creating new business models that revolutionize the industry. The right IP strategy in a company focuses the organization's IP efforts on filling performance gaps in the lowest level, gold level, as a top priority. So that means even if you want to have it all, no, you have to go step by step. Only after an organization's IP performance at that level is in control and sustainable, an organization then can tackle its IP priorities at the next highest level. Adéla, may I involve you again? Let's assume that an EIC applicant submits that pyramid, saying, look, I have the IP strategy already there for the next 40 years. Okay, Thomas told me to be forward-looking, to have the telescope, and that's what we are aiming for. So look, this is the perfect IP strategy. We do it all. Would that secure the funding? Would you be happy about that?
Well, I would say we would not be happy about that because actually you rightly stated before that IP strategy should be individual to the company and it should not be a copy-paste. So of course, if we see, let's say, something that is very complete and that is standard copy-pasted, that will not be the right thing to do. But what is also not correct about this is that you cannot aim at everything. You should prioritize. You should prioritize what your goals are, and you should select those that are relevant to your business. So I would say, of course, you can combine them. It's not only that you should be aiming at one thing, but you should find the right combination for your business that makes sense from the business perspective for you.
Yeah, makes perfect sense. Thank you. Yeah. So this is good for understanding, for having the 360-degree view on the topic. But this pyramid is also very helpful when running a workshop in your organization, in your environment, to discuss how to develop and advance your IP strategy. So it's highly practical because that is setting the stage. If that would be the main thing that you take with you from that session, then I would regard it already as a success. I can make you sure that that will help you in practice for advancing your IP strategy or developing a new IP strategy for your yet to come business. Yes, but we have more for you. As already mentioned, IP strategy is tailored also to your industry, as there are different requirements. For example, when you compare biotech with information communication technology, so there it is obvious, but that is not just about a tradition that in these industries they always behaved in a certain pattern. There's a reason behind it, and that is illustrated by the next slide. So there are two important aspects to consider. So the best market business segmentation to use is one that segments industries by the time it typically takes to invent new products and the time that it takes to bring, so that's here in the upper part, and the time that it takes to bring those products and services to the market once the technology for them is being created. This matrix was created by, filled by studying over 800 companies by the Industrial Research Institute and analyzing how R&D was designed, organized, funded, and commercialized. And you can see here the extremes, so short to create a design and manufacture something. The extreme on the far right bottom is these are newspapers, news programs, clothing, food. This goes fast. And the other extreme is biotech, self-driving cars, artificial intelligence in medtech. You need a long science discovery period. and you are confronted with government regulations, etc. So it will take its time. We will not get into the industry specifics as such. The main key takeaway is that it depends on the industry in which you are working, what to expect, what are the typical boundary conditions that you are confronted with, and where are your peers to be found from which you can learn. Peers, for example, like in our case study selection, to see which companies that we have featured there that have disclosed their IP strategy and IP management approaches, from whom to learn, because it's industry specific. Good, then let's go to the next point. So far, we analyzed the right IP strategy from an overall business standpoint, an industry segment standpoint, and the company competitor standpoint. But now we will compare the companies and the competitors' products pairwise on the likely cost to offer that product or service to a consumer. So the cost dimension versus the consumer perceives the relative performance of the two products. So that means price versus performance. So we have to see what is doing the job for the consumers or for the buyers. What is the cost benefit analysis for the recipients of the technology? Well-run companies tend to have all the products and services mapped into one of the three quadrants shown in green. So they have a focused approach. They don't have the product once in this section, once that section. No, they focus. All of the functional groups, mission, and goals aligned to do so. This is because corporate branding requires all products have the same image or brand promise, or customers become confused. Of course, when you're working in a startup situation, that might not be a strict rule, but it is something to be considered. Examples, large traditional pharmaceutical companies tend to operate in the upper right quadrant. So superior consumer features. They have these features that appeal to consumers. Organizations like I already mentioned, Ryanair, Lidl, Aldi, tend to operate in the lower left. They have a low cost appeal. They rely on low cost. That makes it attractive for the customers. Both these positions are viable long-term positions as long as the company maintains focus and consistency in managing its product lines accordingly. Bad examples are when, for example, some years ago, Mercedes started to sell cheaper cars and the consumers got confused. And answer the question for me, will Apple ever sell cheaply priced iPhones? I don't think so. So organizations are most successful when they operate and offer products in the upper left part. So hopefully most of you are in that part. To succeed in building their business, they must offer superior consumer features at low cost. So the combination of both. And these are the commercial winners in all scenarios. So that is what you are aiming for. Over time, fast-following competitors typically move their positioning in either to the right or to the superior consumer features, or to the bottom to the low-cost appeal. When you have to move, when businesses move in both directions at once, they are on the poor cost and poor feature section, and either they go bankrupt or they are in a very special niche where they still can sell their own products. So probably not very relevant for you, but to be systematic, we have included it here. So what does it mean in respect to IP? The next level of detail is to consider what IP to protect for all these cases. The upper left IP strategy, that means to protect these product services extensively with every form of intellectual property possible, because that's the cash cow of the company. That is that where everyone wants to be, and that means the copycats are just around the corner. So you will study what Bente has presented and which of the IP rights can be used to protect these valuable products and services. The upper right part, there you will be more specific, in particular when it comes to trademarks, etc. So here it's not all in. Here it is with a focused approach. The low cost appeal, that is more something for trademarks, for copyright, and limited trade secrets. So usually patents don't play a role. I already mentioned the exemption. That is when you revolutionize the production of goods, then that can make a difference. And the lower right IP strategy is clear. Don't waste money. Don't put money into that basket. That will not be successful. So then now coming to the next slide, that connects to what Bente already presented. So this graphic, I think, is a very helpful one to talk about the timing of the IP rights. So what is when highly relevant? And it connects to what I said at the beginning, that the IP strategy evolves with your business. So when you might have been very focused on patents in the early stages of your company, that might change over time. And with that, we fulfill the promise that we gave at the beginning, that we said, let's talk about the telescope view. It shows, so to be clear, so here we have the axis, which is value, and that versus the time axis. With a patent, you have a protection for up to 20 years. You have already heard about that. So that means the overall time axis that we illustrate here, that is about 40 years. You might now think, what do I care? I care about the next 3 to 5 years. That is already a long-term planning. It is important for 2 reasons. First, understanding the overall picture that makes you learn faster as you benchmark with the right companies. So if you benchmark, you want to have the peers that are in a similar situation. You can't just copy an IP strategy from a big company, for example, and make it a little bit smaller. That will not do the job. Second, what you do today will set the bar for tomorrow. For example, when you file your first generation of patents, this defines the state of art for the second generation. So I think I mentioned when I talked about the business case or the case study of my father, that he filed follow-up patents. And the examiner, they always came with his earlier filings. And the earlier filings defined the state of art. And for the inventive step, he needed to get over that hurdle. So that means whatever you put into your patent will define what are the potential follow-up patents. In a defensive patenting strategy, this could make sense to put as much as possible into that in order to keep the competitors on distance. But you need to be aware that this is also the benchmark for yourself. Yes, and another aspect is that I already stressed the example with Gore-Tex Insight and all these companies that followed that aspect. Nearly all of these companies cited, they all started with technology. They had patent protection on which they could rely, but early on, they have decided to put a trademark in place, to use it accordingly, to use the negotiation power they got by their patents, negotiating with their customers that integrated their products in their products, and enforced that they were displaying their trademarks on the final product. So that was a smart approach, and that they started very early on. So therefore, you should have an eye on it. So with that, we are coming to the another aspect that will be of high relevance for you, for your IP strategy. So I said that the filing tactics as such are not the main part of an IP strategy. Having said that, the IP strategy, and that means finally your business case, will define where you need to have the patent protection. And implementing the right IP strategy, it's important to remember that every well-run organization is very cost conscious. And everyone knows that it is also a long-term investment. It's a kind of marathon that you run, and you don't want to waste resources. You want to make sure that you get a return on all your investments, including those investments that you have made in IP. So in general, the best IP strategies tend to focus on geographic coverage, where the most sales and profits are made. And you can follow the 80-20 rule. It's a good place to start when naming specific countries in which you file patents, trademarks, and you also care about copyrights that can be different from nation to nation. So you want to know where you want to get the protection. And consider to seek IP protection in those countries where your competitors are located, even if you have no market share to protect there. But it can be the means to stop them producing when they want to start the copycat approach. When you plan to license, check also where the licensors and the competitors protect their technologies. They might not, the licensees might not be prepared to pay a premium for coverage that they don't need and where they don't file themselves. Again, in both cases, the slides are very well suited for your own workshops defining your IP strategy. I think that can add value and set the scene for the internal discussion that you will have. Now I'm coming to another tool that will help you in implementing or creating your IP strategy. So that is a tool that we as the EPO offer. It's called IP Score. It's a free assessment tool, and that we will explore more deeply on day 2. But I think it already makes sense to mention it for several reasons. One is, in short, IP Score evaluates your IP situation across 5 categories. And in each category, you have 8 questions. So actually, it's a checklist of 40 questions in total. And what you see here is a preview of the 8 IP strategy questions. Each question is rated from 0 to 5, helping you to assess both strengths and weaknesses in a spider radar graphic, and allows you then also to compare several technologies that you have. That is what it was originally made for. So let's assume you have the budget for funding 5 applications, 5 patent applications, and also 5 you have 5 options to develop products, but you have 9 in your pipeline. So that means you need to deselect 4 to get from 9 to 5. Yeah, and when you want to have an informed decision making, you want to have a systematic approach. And that helps you exactly to do that, because it also allows you then to compare the outcomes of the assessment. But there's for now, the real takeaway is that when you go through all the 40 questions, you will realize you can't answer them alone. And I always come back to one phrase. When you hear me speak, it's coming nearly every time. Everyone can innovate, but no one can innovate alone. Innovation is a team sport. And that's exactly what the next slide illustrates. So what we advocate for is informed decision-making. In order to have an informed decision-making, you need to involve many in the fact-finding and in advancing of spotted weak points. Even with all the talk about today about teams working closely together, it is unfortunately still typical to find organizations that operate as shown in the left-hand graphic. in most companies, legal and R&D are organizational elements that are acting separately. They are in their ivory tower, more or less. And in order to really get the IP strategy right, it is almost imperative that they operate as shown on the right side. Aligned companies have already a good business, legal, and marketing interaction, but they still leave the inventors out of the process, which IP-driven companies avoid. If you have your own production in IP-driven companies, this is also an asset. So the production, to have the production people included in the discussion, because that gives you really the 360-degree view on the topic. And that is what you need for informed decision-making. That means that the organizational structure of your organization is strongly related to your ability to implement, to create and implement an IP strategy in a good way. And that is all about communication. So as I already mentioned, IP's innovation is a team sport. And for an IP strategy, you need to get people on board, and you need to communicate, and you need to be able to communicate about the IP strategy. Otherwise, people will not work all in one direction. It will not be efficient. And one of the reasons why it is so natural to have all these departments separated, like indicated here on this graphic on the left side, that is because they all speak different languages. You know, people that have a business education have some similarity with the market people, but for sure they don't speak the language of lawyers, and they don't speak the language of the inventors or the scientists and engineers. So there is a communication issue. And Ilja already raised that point, that when IP departments, IP professionals talk with their CEOs, CTOs, with their founders, they should use business terms to be understood and to be taken seriously. And it's going in all directions, because you want to have enough understanding of the others to be able to communicate properly. That's one principal aspect. And when it comes to IP strategy, there is also a high value in communicating at least part of your IP strategy. Of course, there might be things that you want to keep secret. But remember the case study I presented about my father. If he would have been transparent to the licensee, and the licensee would have been transparent to my father, if they would have had a good communication, then they would have built up trust that would have allowed them to renegotiate the license contract. So that was one of the main failures that were there. And that is why I argue much for having a good communication and learn to communicate with the others, even if they have a different education, different culture, different approaches, but be open-minded to do that and develop this additional layer of skills. We already talked about the 4 reasons to patent. That is what Ilja presented, and there is a link. We have done that in cooperation with 4IP Council. And the good thing, if you use that link, is that there we have linked our case studies, meaning the different scenarios that are there, why companies have opted for patent protection, how do they use their patents. Then you see corresponding case studies. We will have some now later on, but here you can go by yourself and find the case studies that are telling for you, depending on what is important for you. But what I wanted to give also into your hands, that is another slide that can help you when you are having your workshops, because for every, for your IP strategy, but also for every patent that you file, you should know why you file, why you protect, what is the role. So the different reasons are listed here. And it is a little bit done like a word cloud. So that would be a good practice, that when you have several reasons for a certain patent, that you want to file it and keep it alive, that you make clear what is the primary use, what is the secondary use, why do you have it, and that you reevaluate that year by year whenever you have to do any payments, annuities that you finance, that you are aware about why you have it. And there are sometimes also slightly opposing aspects like defensive or offensive. For one single patent, you do it either this or that way. And defensive just means you focus avoiding litigation, like we already talked. It is a lot about FTO. You want to build fences and thickets for competitors so that they don't have an easy ride, but you don't plan to enforce. It's mainly about selling your own products and services to keep that working. But you can be also more offensive, and you have an active monetization strategy that includes that you want to license, and if someone doesn't agree to license terms, is using it, you are prepared to litigate. Yeah, and so you want to control the market and prevent the copying. So these are then the different reasons to use IP. Including, of course, also a very important point of negotiation and exchange. I already mentioned several aspects in that. And in particular, when it's about EU-funded projects, so that's a hot topic, of course, then you want, and we already mentioned the consortium agreement, then you want to know who owns which IP, background IP. You want to have the regulations for the foreground IP, the newly created IP, who gets access to it, who owns it. You want to have that clarified. And your IP strategy and the IP protection that is already in place will make it much easier for you to have a good way to negotiate and find a good compromise, so that finally the joint, so finally you come back to what I initially said, that you have a win-win cooperation where everyone is eager to contribute to the best he can. Good. We are coming with that. We are coming to an end of that part, which started with a first case study, where we discussed what an IP strategy is, how we implement an IP strategy, how we create an IP strategy, what are the tools that facilitate life for you to make use of what you have learned here. And now we are coming to more case studies to come more in a discussion style with Ilja and with Adéla. So now I'm looking to my colleagues. Maybe you can activate your camera. So after me talking for a longer time, it could make sense that you add case studies, add comments right away, or I present Aerogen as you like.
Well, if you like, Thomas, maybe I can continue with the case study of OncoCure.
Yeah.
And then we can give the word back to you so that you have a little break in the meantime and you can catch the breath a little bit.
And go for the physiological need.
Indeed.
Fight against dehydration.
Okay, very good. So I will share my screen with you. I will just in a couple of minutes present to you an example of an IP strategy from the company OncoCure. Right at the beginning, I have to apologize. I caught a little bit of cold, so in case I have some issues with my voice, then please excuse me. So OncoCure is an Austrian biotech company. We have actually prepared together with the EPO a case study about this company, which we described. You can find it on epo.org/SME. The EPO SME case studies are basically case studies that are describing IP strategies of different companies. And I strongly advise you to go to the EPO website and look for these case studies, because they are very inspiring and maybe they can serve to you as an inspiration for creating your own IP strategy. So OncoCure is developing a technology that is called specific total immune remodulation, or shortly STIR. So the STIR technology is a platform technology, and it serves for development of immunotherapy vaccines. I have put here a picture for you so that you can imagine what the technology looks like at the molecular level. The vaccine as such that is used for treatment of cancers or allergies is composed typically from 2 modules. There is the first module that you see on the left side in the picture. This module they call the warhead. And the warhead is basically, the function of the warhead is to carry the second module. So the warhead always stays the same. In every vaccine, the warhead will be present, and it will fulfill the function of delivering the second module to the cells of the immune system. The second module is an immunogen. And the second module is what changes in every vaccine, depending on which disease is targeted. So based on what immunogen you connect to the warhead, you can treat either different types of cancers or different types of allergies. So when we say that OncoCure has a platform technology, what we mean with that is that on the basis of this technology, many different products for different applications can be developed. That's what we mean by a platform. Now, what is the IP and business strategy of OncoCure? So as Thomas already explained very extensively in his presentation, when you are thinking about your IP strategy, you need to think about your business objectives, what you are trying to achieve. So in the case of OncoCure, we can say that their main goal, at this moment at least, is the development of the first pilot product to pave the way for other products. Because as you know, that in biotech, the time to market is very long. In case that you are developing a drug, which is the case here, you have to go through many stages of clinical development, and this phase typically takes a very long time, and it's a very cumbersome process. It takes also a lot of money. And OncoCure knows that once they have one product approved, the other products will, let's say, easily follow. So what they are trying to achieve is firstly to have the first product approved so that the others, let's say, can get approved with an easier process. Then there would be some also let's say, secondary goals. The immediate goals would be, of course, protection from competitors. That's, I think, applicable in most cases. Also creating negotiation leverage with licensing partners or potential collaboration partners. In case of OncoCure, it is also securing financing of R&D, because OncoCure actually mainly finances its own product development with licensing revenues and also partially with public funding. So licensing revenues are very important for them, and so securing financing at this moment for the development of the products is also an important goal. Among some of the long-term goals, we would have partnering with big pharma for the, let's say, later stages of clinical development, and of course securing return on investment, because every company, even if you have the motivation to do the right thing and to, let's say, improve the treatment for the patients and so on, of course you need to get the return on your investment at some point, especially in biotech where the time to market is so very long. Now, what is the IP strategy of OncoCure to fulfill or help to fulfill these goals? They have a broad patent protection of the main elements of the warhead. So the warhead, as I already explained, is the core of the platform, and having a broad protection of the platform is one of the most important things that you should do when you have a platform technology, because that actually helps you to protect all the products that are created on the basis of the platform. So let's say any vaccine that is created on the basis of the platform that carries the warhead in it will be automatically protected when the warhead itself is protected. So this is the first thing that contributes to the objective of developing the first pilot product, because this helps the company to develop several different products at the same time and have them all patent protected. Then OncoCure is also filing for product patents. This would not be mandatory, let's say, but they do it as well. Because, well, as I said, every product is protected by IP rights already because it carries the warhead. But because OncoCure wants to ensure long-term return on investment, and it knows that it will take a long time until the product gets to the market, this is actually a good way how to extend the time of the protection of certain products. Because let's say if you 5 years later, after patenting your platform, develop a product that you then protect with a specific product patent, then you have extended your patent protection for that specific product. So this is also one of the IP measures that the company is employing. And lastly, also combination with trade secrets. This is something that I would also recommend you to consider, to combine patents and trade secrets. Not to choose just the one or the other, but think about a smart combination, because if you are combining patents with trade secrets that cover some additional know-how, data, and so on, you are strengthening your protection from competitors. It's much more difficult to imitate your technology. And you might also be extending the IP protection of your technology. And you might even achieve that your licensing agreements will be continuing even after the patents have expired. If you have protected by trade secrets some information that is still useful for the licensees, for the production of the product, and that is still worth paying for. What OncoCure also does is that they file very broadly when it comes to geographical coverage. And that is because one of the long-term objectives is also partnering with Big Pharma. And Big Pharma, as you might know, is notorious for always mostly aiming for very broad geographical coverage. So OncoCure wants to have this geographical coverage already very broad so that they can increase their leverage for negotiation with Big Pharma. Here I can show you the main patent families of OncoCure. There are 3 patents that cover the warhead, so the core of the platform. And there are at this moment also 2 product patents. So as I explained to you, those additional patents that might then extend the protection for specific products. So those are the main patents that are covering this technology. In this slide, although it seems a little bit complicated, I would like to show you the business and licensing structure that they have in place. I will guide you through the slide so that you see it's actually not that complex. In the middle, you can see the company OncoCure. On the left side, you can see Astarget Therapeutics, and on the right side, you can see TYG Oncology. So those are 3 companies that are currently using the technology for development of different products. OncoCure and Astarget actually have the same co-founders. They are separated because Astarget Therapeutics is dealing with allergy products, and OncoCure is active in the cancer field. That's why they separated these 2 companies. Astarget currently owns the patents, the platform patents 1 and 2, and OncoCure owns the platform patent 3, and they are giving each other a license. So there is a cross-licensing deal, let's say, between themselves. That ensures that both of them have freedom to operate. Let's say both of them can use the platform for product development. Astarget Therapeutics then further licenses these 3 patents to Allergo Pharma and Angotera that you see at the bottom left for development of products for treatment of allergies. OncoCure is further licensing the 3 patents to a company that has not been disclosed to us for development of a certain product related to cancer therapy. OncoCure is also by itself developing one product, that's OQR200 for breast cancer. And it further licenses the 3 patents to TYG Oncology for development of a product for gastrointestinal cancer. And TYG then further licenses to Apollo-Mix. So it's actually Apollo-Mix that is doing the product development. So you see that this is quite a complex structure or sophisticated structure, I would say, that was created thanks to the IP. So they were able to bring all those players together and set up these licensing deals in collaboration with different companies, so that they can in parallel be developing several products, and that's what the platform enables. So just to wrap it up, this smart IP strategy allows OncoCure to multiply the pathways towards commercialization, let's say. So not only that they are doing their own R&D for one of the products for breast cancer, but they are also licensing out for gastrointestinal cancer, then to this undisclosed product in the cancer field, and they are also licensing out to companies that are developing vaccines against allergies. So this is something that IP enables, and I would like to stress, we like to say that IP is there for you to create options. You should see it like that. You shouldn't see IP as, sometimes it is said that it's a costly insurance. It's not a costly insurance. It's also not an arbitrary requirement of funding agencies or something like that. It's really a tool for you to create options and to help you fulfill your business goals. As I imagine that we have a lot of biotech startups in our audience today, I would just like to wrap up what are the advantages of having a platform, because I believe that for many of you, this might be a relevant, let's say, inspiration for your IP strategy. So having the platform for development of different products allows you to firstly multiply the pathways towards commercialization, which is very important in biotech, because you multiply your probabilities, or you increase your probability that at least one of the products will enter the market once. It also can enable you to finance your own R&D through licensing. That's something that OncoCure has achieved really excellently. So the product OQR200 has been to a large extent financed by licensing revenues at the moment when the company actually doesn't have any product on the market. It doesn't have product revenues. So that's also something really interesting for you to consider. It can create additional revenues for your product development. And what is also quite relevant to mention is that it also can help you save patenting costs, because there will be many companies in the audience that for sure have are very early stage, and they are on a very tight budget. And having this kind of strategy and having these let's say agreements with all the licensing partners can also help you to, let's say, shift the burden of the patenting costs towards your licensees, at least partially. Of course, it should always be a fair deal, but at least partially it can allow you to save some patenting costs. So that's also worth considering. So that would be all from my side at this moment. I will be very happy to take questions, but I would say we should do it at the end of this session in the Q&A. So Thomas, back to you. You are mute. We cannot hear you. You are mute, Thomas.
Yeah, thank you. I think that was it was great to add these experiences from OncoCure case study. Just to mention, Adéla presented the overview, the graphic. These things were not created by doing literature research. All those case studies are based on interviews of the businesses. So this is all validated information. At the time when we published, it was to the best of our knowledge and the best of the knowledge of those companies, the latest status of the information that was available. I think that's also interesting to understand when reading the case studies, that this is actually privileged information you get access to. because we have invested a lot of effort to give you the whole picture, because many things that you will hear from IP advisors, from experts in the scene, might sound like contradicting messages. Sometimes people say file patents as early as possible, others say file as late as possible. In the right environment, both might be completely right, but it depends on the circumstances. And the case studies, we have put a lot of effort in describing the case, the environment in which they work, the technology, the market, and all these aspects, so that it is understood why the one or the other strategy was a winning one in that respect, in that environment, and also that you can really learn from that. And with that, I would like to hand over to Ilja, who has also prepared a short case study to add the learning.
Thomas, thank you. Yes, before I present the case study, let me present the series first. Because you were talking about the innovation case study series, and I just want to give you the address where to find it. So you see it below, just to sum up. So there are over 35 case studies, 22 based on interview and expert insights, 10 additional ones based on panel discussion and recorded interviews and presentations online. We have two types. You can follow a company from its beginning until its market success and beyond, but also you can follow technologies, because we know, and I guess it's also the case for most of you, that the technology originates from a university or public research organizations, and you will find case studies that start with the development of the technology at that organization and then describing how that technology was able to reach the market. And we try to make it as diverse as possible, so you will see different technologies and different business models. And we should not forget, in Europe, we still have different regulations and environment. This is also taking into consideration. As you can see here, I think we covered most of the countries in Europe, and every country has its own peculiarities, its ecosystem, and we've tried to reflect it in the case studies. It's also a project that is still developing. We are currently completing a new series of 3 additional case studies where we have a focus on investment, also investment from the EIC. And we will continue developing more case studies in the future to add to the collection, because as you know, technologies are different and markets are different. Nevertheless, also technologies and markets are different. Adéla, I think there are many parallels to the case study that I'm going to present. It's a case study about a Swedish company, Oxion, which started around the year 2000. It's a technology developed by an inventor at the Chalmers University of Technology in Sweden. And he was able to find an angel investor who supported the development of the technology and the first steps in cooperation with the entrepreneur school at the Chalmers University of Technology, where the students actually developed a business model and supported the inventors in making the first steps into the markets. And here the markets is already an important word here. The technology itself is a weaving technology to use different types of fibers and to use a kind of a spread tow process, which allows you to combine different types of fibers, such as carbon or some other types with certain features into a sheet. So it's a weaving technology which allows you to make the final material that you have at the end lighter and stronger. And as you may already see from the pictures here, these materials can then be used in different applications. And when developing the business case, the students, but also the inventors, for them it was clear that they were targeting the aerospace market because of the size of the market and the usefulness, the value that technology, and just to remind you, this is a material which is much lighter and at the same time stronger. So it has features which are very advantageous for for that market. However, what they will also quickly realize is that the entry barriers were very high. First of all, because of their regulatory requirements. Second, because the procurement cycles were very long. And third, because you first have to prove the technology in that industry. So it's not easy to enter it. Therefore, what they did is that they worked on the development of an IP strategy, so in particular an IP portfolio, to make sure that they protect their technology along the full value chain. And why is that important? Because first of all, they knew that protecting the technology, the manufacturing process itself was important for many industries. At the same time, they were aware that before entering the aerospace industry, they needed to generate money and to prove their technology in different markets, which were much more open to new technologies and where they can show the usefulness of the technology and the value of the technologies for the different actors. So not in the core market that they were targeting, which was the aerospace market, but in other markets. And I will show it on the next slides. But how to align the IP strategy to that business objectives? Well, they asked the question what and where to patent, and they realized, or at least together with the IP experts that they had to protect both the manufacturing process itself and at the same time along the value chain to be as close to the markets and to the customers, the material which we are adjusted for the different markers. What are the factors to consider when making the assessment? It's the own needs. So what are the needs of, in that case, of Oxion to enter the market and to follow the business strategy that they had. Of course, to assess the customer needs in the different markets and potential license needs, because from the beginning, they did not exclude also the strategy of licensing, not the application, but to license the weaving technology into markets that they were not aiming at entering. So markets where they were not competing with others. So just to summarize the strategy that they had, so as you can see, they were focusing on product sales, targeting the aerospace market, so application. But before that, they were entering the sports equipment market in particular, and I will show you this in the beginning: skis, tennis rackets, but also in the Formula One applications. These were quick wins. It generated revenues, and they were able to prove their technology to different applicants, which then made the way. They opened the way to the aerospace market. And as you can see, their most recent success, at least the one that I looked at, is that their technology and the material was used to reinforce the rotor blades of the Ingenuity, which was the helicopter that landed on Mars a few years ago. So you see at the end, they indeed succeeded in the market. Just to check their success. So they started in the sports industry, and at the end, they really landed on Mars. So they reached their goals to enter the aerospace market. At the same time, they saw the possibility to license the technology into a market that they were not aiming at entering. And it helped them not only by generating revenue that they used then to develop their products for the aerospace market, but it also helped them to show that their technology, the weaving technology, was applicable in different industry sectors. So there are different advantages from the different strategies. And just coming back to the previous slides, it's all interlinked, as you can see, with the IP strategy, where they really thought about how to protect, where to protect, and what to protect. Now, just to summarize the key takeaways, and again, all the details, I know that was fast and quick, but I hope I raised your interest to look into the particular case studies and study what exactly the company did and how it prepared for the different steps in their future, and how they prepared not only business-wise but also IP-wise. So here again, the marketing strategy was to enter first into the niche markets, to build sales and brand awareness, and also to gain trust in their technology, in the products that they were able to deliver, and that opened the doors for the market that they were actually aiming at. Then you see how they use strategic patent protection, and here the keyword is patenting along the value chain, and they followed that strategy, and you can read more details in the case study. Then they did not exclude the licensing possibility from the beginning, and were actually actively considering that already from the beginning in markets that they were not aiming at entering. And last but not least, I know I might have started with a patenting story, but it's not a purely patenting story. They used all means of IP protection, dependent on the usefulness for the goals, for the business goals that we're aiming to achieve. So they really combined patents with trademarks and also trade secrets, especially in those cases where infringement was very difficult to detect, especially in the manufacturing processes. So back to you, Thomas.
Excellent, thank you. So I think with the two case studies, we have already achieved all the technical goals that we wanted to address. I would just have a final key takeaway slide to share. The case study that I mentioned before, Aerogen case study, I will include it in the slides that we will share with you, so that you have another case where you can have a look into how the learned aspects can be translated in one particular case. It's a case study that is online. You can read the case study, you can go through the slides, so you have some further reading to see how in practice this is applied. So just another example, but I would share now the key takeaways that will then pave the way for the Q&A. So, yeah, you should see them now. So to sum up, there are just a few points. IP supports your business strategy, not the other way around. IP strategy defines the direction, and IP management wins the battles. Use the tools that we have provided to you to tailor the IP strategy, but don't copy them. As already discussed with Adéla, this is not the winning approach because it's tailored. That is essential. Adjusted to your particular situation. And another aspect is the informed decision-making. That is what you have to aim for, and that requires communication internally and externally. So once you have your IP strategy in shape, think about how you are going to communicate that so that it can develop its positive effects in your relationships externally, but also, and foremost, of course, that all people in your organization know the direction. They know why they why you are going in a certain direction, why are you filing that patent, and so on. So they want to know it, they need to know it. And learn from failures. Speed up by learning from failures of others. Don't need to do all the failures by yourself. Of course, all those that you have done by yourself, you will never forget. So that's good. that's intense learning. But fast learning means that you observe the others and you don't need to redo what they had to learn the hard way. That will speed up your whole process, and that will increase to a significant, in a significant way, your success rate. And so I would hand over now to Stephanie, our moderator, to see which of those questions that we have not yet addressed online we can address now in a kind of panel discussion. Thank you.
Thank you so much, Thomas, and thank you everyone for sending your questions. There's still quite a few, I should say, and let's see whether we can address them all. Apologies already if we don't, but I think we've already touched upon numerous aspects. Maybe then another question more concretely for Adéla and the EIC concerning support initiatives. So we had one question coming in that, of course, it's quite complex and all the steps that you need to take. And someone is asking whether there are, partnerships, support initiatives that help EIC beneficiaries in crafting IP strategies or even, giving tips to implement IP management processes.
Indeed, yeah. So I would recommend the beneficiaries to have a look at the EIC service catalog. I will put the link in the chat, but I'm sure that so all beneficiaries should know the EIC service catalog, and there you can search based on keywords or based on topics, and you might be able to find services that could help you with designing your IP strategy. One that I would like to point out is the IP due diligence service. The name is a little bit misleading, but you can also use the IP due diligence service for refinement of your IP strategy. So we have a list of experts listed in the EIC service catalog, and you can pick the expert that that let's say suits best your needs or whose profile is the most relevant. And another thing that I could mention is the EIC business coaching, because as we have learned today, IP strategy is very closely linked to business strategy. So when you are working with your coach on your business model and business plan, you might also then tie in the IP aspects, and you can discuss it with your business coach. Stephanie, I would just like to tell you, I accidentally moved one question to the answered section, which I didn't want. I wanted to answer it actually.
Okay.
It's the one that one person seems to be already asking twice the question regarding the product that is already on the market and whether he or she can protect it. I don't know if someone else would like to take it or if I should answer. However you prefer, but I wanted to make sure that this question gets answered. So maybe I can start and maybe other panelists can then add some thoughts. So indeed, when you have a product on the market already, then you have basically by yourself destroyed the novelty, which is one of the prerequisites of patentability. So that product in Europe, at least, is not patentable anymore, at least not under the European Patent Convention. But you might still check if there are other territories and other countries where this would be still possible, because there are other countries outside of Europe, for example, the US, Japan, I think as well, that allow what is called the grace period. And that means that even if you by yourself disclosed your technology already, but if it's within a certain period before filing your application, it is still admissible and you can still get patent protection. So maybe in some other regions you can still get the protection. And in Europe, you might check if there are some countries that allow grace period for utility models. And then you might be at least opting for utility model protection in Europe and not patent protection. Maybe EPO colleagues, I don't know if they would like to, because that's actually their topic.
Yeah, so I would also like to add to that. It always makes sense to consult in such a matter a patent attorney to see what really was disclosed with the product. Because if it's if it's a mechanical thing and you just open the product and you can see what is there, then you might have bad luck. But if it's not obvious what the technical solution to a technical problem is, and it's more like a black box, then you might have a chance. But that is something that needs to be evaluated case by case. When I was doing the technology transfer at the university, we even had a problem with a hydroelectric power station because it was on a construction site implemented, but the construction site was not completely shielded, so people could make pictures. And when they made pictures, they saw how the stream of the water was organized to increase the efficiency of the hydroelectric power plant. And then together with the patent attorney, we concluded this was actually the main idea. The main idea was disclosed. that was obvious, and everyone who made a picture there would have had a proof to show that there was prior publication. So it was made obvious, and therefore you lost it. But the point is that you need to understand what would actually be the main things that you want to protect via claims in the patent, and what of that is now state of the art, increasing the barrier or the level of that you need to prove that you have an inventive step. So that is the crucial thing that you need then to analyze. And as Adéla rightly stated, there are always some options, so with grace period and so on. And when it is of high commercial value, and when you see that that is really something that makes you cry, then talk with the experts and find out what the real damage now is that is caused and what still can be rescued.
Thank you very much, Thomas. So we're hitting the 5 o'clock mark, and I think we'll we'll close here on time. So thanks again for well, to all the speakers and to you for taking the time to share your insights and perspectives this afternoon. You had already this brilliant takeaway, key takeaway slide. So maybe just to potentially echo that. So IP is not only to be seen as a legal protection tool, but really as a strategic asset. We have to think beyond patents. I think that's what all speakers repeated, because it's also an indicator of, your ability and your capability to deal with IP and IP management. There's no one-fits-all solution. So you have to tailor it, and you actually have to bring in many people, different backgrounds in to actually make it happen, communicate and translate IP into the different languages to the people that you're talking with. And then, as Adéla rightly mentioned in her talk, it's really to be seen as something, not as a necessity or a box that you have to tick once you apply for a grant, but really see it as an opportunity to create options for you and to help you fulfill your business goals. And with that, I'm closing the session, but I'm also inviting and hoping, of course, you will join us next week. As said, then we will move on to IP management, and just a quick outlook. So among others, you will hear more about the IP creation pipeline. So what is that actually, and how can you improve it? We'll zoom in on identifying, let's call them the technology champions in your portfolio, because maybe not every technology can make it to the top. So how do you tailor that, and how you prioritize and make sure that you protect and how to protect the obvious and the less obvious. So if that doesn't make you curious, I don't know. So I am, as I said, we hope you'll join us next week, and take care and see you then. Thanks, everyone.
Thank you. All the best, and hopefully see you next week.
Thank you. Thank you, and bye.